Hello and welcome to this session in which we will discuss agency law, and specifically we will be discussing apparent authority. In the prior session we looked at actual authority. And what is apparent authority and actual authority? Those are abilities of an agent to legally commit or bind the principal to a third party. In other words, the agent has either actual authority, apparent authority, or ratification we'll talk about later. Those three things, and ratification has nothing to do with the agent authority. We're going to talk about ratification in a separate recording, but those authority can bind the principal from action taken by the agent. We're going to talk about apparent authority or estoppel. We'll explain this in this session as well. Let's go ahead and get started. Before we proceed any further, I have a public announcement about my company, FarhatLectures.com. Farhat Accounting Lectures is a supplemental educational tool that's going to help you with your CPA exam preparation as well as your accounting courses. My CPA material is aligned with your CPA review course such as Becker, Roger, Wiley, Gleam, Miles. My accounting courses are aligned with your accounting courses broken down by chapter and topics. My resources consist of lectures, multiple choice questions, true-false questions, as well as exercises. Go ahead, start your free trial today. So what is apparent authority? Well, it's a legal concept where the one person, which is the agent, has the power to act on behalf of another, which is the principal. Remember, we have a principal agent, even though they don't have explicit permission. In other words, they don't have the explicit power, because the principal's action, here's what happened. The principal's action has led others to reasonably believe that the agent has such authority. What does that mean? We have the principal that hires the agent. Now, because the principal hired the agent, they gave the agent certain authority. Now, some of these authorities might be explicit, some of them could be apparent. How can it be apparent if it's not explicit? Well, you granted them a certain title. For example, if I granted you a CEO title, Chief Executive Officers, what do others think? Others would think that you run the company. You can hire, fire, buy inventory, do whatever you have to do because you're the CEO by the nature of the title, or you're an executive manager or a general manager. This is different from actual authority where the agent has explicit permission from the principal. In an apparent authority, the principal's behavior or lack of, we're going to see what do we mean by lack of, like not correcting false assumptions, lead others to believe the agent has the authority. Because in the eyes of the others, well, it looks like this individual is indeed in charge and they can enter into a contract by the mere fact of their title or their position with us, and they are entering this contract on behalf of a principal. So this is, bear in mind, apparent authority cannot be created by the agent. This is not based on the agent's own claim. So the agent cannot say, I have the apparent authority. That's not how it's created. It's created by action taken by the principal as perceived by third parties. So the principal gave you a title. That title would make others think you have the authority to do certain things. That's what apparent authority is. Let's take a look at an example. Let's assume Sarah owns a clothing boutique and hires Chris to manage it. Well, Chris is the manager. Chris is the agent. Sarah is the principal. Sarah introduces Chris to her supplier and client as the manager responsible for ordering and negotiation. One day, Chris signs a contract with a new supplier for a large order of material. Sarah never explicitly told Chris that he could sign such a contract. Her introduction as a manager in charge of order and negotiation could create the impression among the supplier that the Chris has the authority, although she never told Chris, gave him the authority to do so. But the mere fact that she introduced him as manager responsible for orders and negotiation, that's good enough. Therefore, despite not having actual authority to sign the contract, Chris might have apparent authority because Sarah introduced him as so, and now Sarah is bound by the contract because the supplier does not know whether he has actual express authority or not, but the apparent authority is there. So if Sarah disagrees with Chris' decision, she may hold Chris accountable, the agent, for overstepping his bounds, but the supplier would expect Sarah to honor the contract based on the apparent authority she conferred on Chris. Let's talk about something related called secretly limiting instruction. There is this principle, the principle of not affected by secret limiting instruction. And this is in the context of apparent authority, means that the principle's private or undisclosed restriction on an agent power do not affect the agent apparent authority as perceived by third party. Now remember what we said here. We said that Sarah never told him to do so. But even if Sarah told him not to do it, even if Sarah explicitly said you are not allowed to do so, well, in such cases, the agent apparent authority is judged based on what reasonable third party would believe. It's secret. The third party is not aware of this. Not on hidden instruction the agent received from the principal. So let's take a look at another example. Rachel owns a bookshop and hires Jordan to manage it. In the book industry, it's common for store managers to have the authority to order new stock. That's normal, and as a manager of the store, that's part of their duties. Rachel tells Jordan that he can order books, but he should not spend more than $500 on any single purchase. So this is basically, in quote, secret instruction or undisclosed instruction. This limit is private instruction and not known by suppliers. One day, Jordan ordered a rare collection of books from a supplier for $700, believing it's a beneficial deal for the store. Now, what happened? Jordan exceeds the limit set by Rachel. Now, the supplier is unaware of this internal cap because that's a secret. That's between Rachel and Jordan. But they believe that Jordan has the authority to make such an order based on his position as the manager. Also, in this situation, Jordan has apparent authority to place the order. As a result, Rachel is what? Is obligated to pay for the books. Can she hold Jordan accountable? Yes. But again, secret instruction or undisclosed instruction, the supplier is not aware of it, the principal would still be held responsible. General agent and special agent, just two terms you need to be familiar with. We're not talking about FBI special agent. We're going to see what this is. The distinction between a general agent and a special agent lies in the scope and continuity of their role. So what is your role? What are you supposed to do? A general agent is involved in ongoing continuous activities for the principal that include a wide range of duties. This ongoing role often grants them broader apparent authority because you might think this individual is responsible for this and that, they must be responsible for something else. In contrast, a special agent is appointed for a specific, often one-time task which limit their apparent authority to that particular assignment. Let's take a look at an example. We have a real estate company and Emily hires two individuals, Robert and Laura. Robert is hired as a property manager responsible for overseeing multiple properties, handling rentals, and maintaining maintenance. And this makes Robert as a general agent, as his role involves continuous service and a variety of tasks. Now, bear in mind, the risk here is Robert might appear to have what type of authority? Apparent authority. So this is the risk here. On the other hand, Laura is hired for a specific project to coordinate one-time open house event for the new property. That's her job. Laura's role as a special agent focuses on a single task without ongoing responsibilities, and this is gonna make sure she does not have the apparent authority. Termination of apparent authority refers to the process of ending perceived power. Remember, apparent authority is not actual, it's apparent, it's perceived by third party on behalf of the principal. So third party thinks this individual has apparent authority. So how can you end this authority? So when the principal ends actual authority, that individual is no longer allowed to do certain things. Actually, you explicitly communicated that to them. It doesn't automatically end their apparent authority because in the eyes of third parties, they might be still able or responsible to do that. Therefore, how do you end this? To effectively terminate apparent authority, the principal must inform third parties who are aware of this agency relationship. Who are those third parties? Well, third parties could be existing customers or business partners. Definitely you want to inform existing customers. Why? Because existing customers already dealt with this agent. Even though you might tell the agent you can no longer, sign a contract or orders on my behalf, make orders on my behalf, the apparent authority might allow this individual to do so. And you want to inform future customers, constructively notify them, because they are potential customers. They're not current customers yet, but they are potential. How can you do so? Well, You may place an ad in the newspaper or in the journal in the industry in which you are operating to let others know that this individual no longer working for us, for my company, for example. Because these people have not directly interacted with the agent yet. Those are potential customers. Current customers, you always inform them directly. You can call them, email them, send them a letter. Once they come into the store, let them know. Just let them know so they don't get into a contract with that individual. Also, what could end termination of apparent authority are the 6 legal events that we discussed in the prior session, which are the death or incapacity of the principal or agent. The agent no longer has the appropriate license. The subject matter destructed. The subject matter became illegal. Remember, there are 6 legal events, and those they could terminate apparent or actual authority. Let's take a look at an example. Maria runs a catering company and has employed David as her business representative for several years. David's interact with various food suppliers and venues on Maria's behalf. Well, Maria at some point decides to let David go and hires Emma. So Emma is the new agent as her new representative. Maria only informs her current clients about this change and does not make a public announcement or inform the suppliers with whom David dealt on a regular basis. Now, let's assume, for the sake of illustration, David, after being fired, remember he was let go, makes a deal with a supplier for a large food order, pretending to be Maria's business representative. Now, in this situation, due to David's apparent authority, which Maria did not effectively terminate in the eyes of the supplier, that's what the supplier perceived. David's still an agent. Maria is obligated to honor the order that David made. Now, to properly terminate David's apparent authority, Maria would need to directly inform all past and potential business contact, like suppliers, about the change through some direct communication or a public notice. Let's talk about agency by estoppel. This is something called estoppel to deny existence, or also known as agency by estoppel. How does this occur? This is funny kind of type of situation, but you need to be aware of it. When one person hasn't explicitly stated another individual is their agent, but their action or negligence led to a third party to reasonably believe that this individual is their agent. Okay? For example, here, let's assume this is the principal. This is the principal, and this is a person that helps them. Now, this individual introduced themselves to this party. I am the agent in front of the principal. Now, he's not the agent. He just helped out at the company, but he introduced himself to this party as this is the third party. So this individual stated, I am the agent, and shook hands, and the principal is there. The principal heard him, did not say anything, did not explicitly stated otherwise. Maybe they heard him, they were negligent, they did not say anything. Well, in the eyes of the third party, this individual indeed is the agent. Therefore, this individual can bind the principal. Or for example, you were at a party and someone introduced you, this is our new partner, like jokingly introduce you as this is our new partner, and the other people believed, maybe they were joking, that this is a new partner in a partnership, and a partner can bind the company with contracts. Therefore, you have to be careful. Or the person introduced themselves, I'm a new partner, in front of other partners, and the other partners didn't say anything. Well, if that's the case, the third party would believe this individual indeed is a partner. So if the third party then acts on this belief to their detriment, the principal is prevented, is stopped from denying the agency relationship, and is bound by the action of the presumed agent, because they did not say anything. They gave the impression, yes, indeed, this individual is an agent of the company. Let's consider a scenario involving a restaurant owner, Kevin, and his frequent customer, Lisa. And if you're in the restaurant business, some people, they go to a restaurant. I know some individuals that go to a restaurant every single day. Indeed, they can run this restaurant if they chose, because they're there every day. They know everything. So Kevin often chat with Lisa about his restaurant operation, and occasionally jokes that Lisa knows the restaurant so well she could run it herself. One day, while Kevin is away, Lisa, seeing the restaurant understaffed and a bit of a chaos, steps in and helps. She takes orders, makes decisions about the kitchen priorities, and even handles some supplier negotiation. The staff having seen Lisa's close relationship with Kevin and hearing their conversation, assume she has the authority to make this decision and followed her instruction. Meanwhile, the food supplier arrives and seeing Lisa's managing things, assumes she is authorized to place an order. Lisa's, thinking she's helping Kevin, places a significant order with the supplier. When Kevin returns and learns about this, he wants to refuse the delivery, claiming Lisa had no authority. Well, because his previous actions and statement led both the staff and the supplier to believe that Lisa has some level of authority in his absence. Whereas Kevin now may be stopped from denying Lisa's authority. He cannot just say, I'm not going to do it. Well, you gave that impression, therefore you are bound with this contract. Therefore, he might be legally obligated to accept and pay for the orders Lisa placed, despite Lisa not being an actual agent. This is what agency by estoppel is. Let's take a look at this multiple choice questions from Farhat lectures. How can a principal effectively terminate an agent apparent authority? We're looking at apparent authority and we want to terminate this. By verbally informing the agent. Now, by verbally informing the agent, you're going to end the agent authority, actual authority, but the apparent authority is seen by third parties. Therefore, A is an easy elimination. B, by providing actual notice to old customers and constructive notice to potential customers. Remember, apparent authority dealing with third parties. So this looks good because we're given notices to old customers, third party, and also new customers, potential customers, third party. This looks good, but let's look at C. By changing the agent role within the organization. No, who knows what the new role is? The new role might give more apparent authority, therefore C is out. By simply deciding not to work with the agent anymore. It does not end the apparent authority by third party. Even if they don't work for you, they could still go into a contract with a supplier, and the supplier believing this individual works for you. Therefore, the best way to do it is to provide direct notice, actual direct notice to old customers via email, text, phone, voice, any way you can, and constructive notice to future customers, to potential customers. What should you do now? You're going to go to Farhat lectures, look at additional MCQs. That's going to help you perform better on your CPA exam, understand the concept better, invest in yourself. The CPA exam is worth it. Good luck, study hard, and of course, stay safe.